Hello, good morning, good afternoon, good evening. I hope you're all doing well this fine Friday. Hope you've all got the Friday feeling. Well, well, I'm gonna tell you exactly what I think about the shit show of yesterday. That's what I'm here to do. Listen, I had a whole live stream planned in my head. I was going to talk about hypothermia. I'd even done the thumbnail. But then she dismissed the jury like a few minutes early. And I thought, oh, okay, they don't want to start a new witness. And that's fine. I almost kind of turned it off. And then Robert Alessi stood up. And we had just over half an hour of complete and total BS. If you saw it, my mind was blown. This is the decisive moment of this trial. This is the issue that this trial hinges on. And Judge Bev is now in a very difficult position. Look, I nearly went live straight away. As soon as I heard it, I was furious. I'm going to get a new blood pressure monitor because I have one, but it's kind of broken and it's old. And my blood pressure normally sits like low end of normal. Like I'm prone to low blood pressure. But I want to get a blood pressure monitor and put it on myself when I'm listening to absolute crap like this. Because I'm sure my blood pressure goes through the roof. But I nearly went live right there. And I thought, no, there's about 1,000 other people live. And I want to calm down a bit. And I want to re-listen. So I listened to it via other people's channels who were commenting on it. So everybody seemed to be thinking the same as me. Like, it's difficult not to think that this is just Hank Brennan trying to manipulate time. That's what it is. Anyway, we are going to listen. So this is going to take us more than the usual hour that I try to limit these recaps to. I normally go over the hour anyway, but this is going to go well over the hour. But we'll be finished well before 2 p.m. my time, which will be 9 a.m. in Massachusetts. And oh my God. If you didn't hear it, then you're in for an absolute treat. Because Hank Brennan, he's a piece of work. He is an absolute piece of work. This guy intends to win at all costs. But if Judge Bev makes the wrong decision here, it's got appeal fodder all over it. If Karen Reid is convicted and Judge Bev doesn't handle this correctly, it's an appeal all day and all night. It really is. Bev's got to say no to it. Well, this is the thing. What choices does she have? I think, personally, this entire case now it's a mistrial. This case needs to be dismissed. It needs to be dismissed because the testimony from the medical examiner, right? She will not change her mind. she will not say that this case is a homicide. She won't. I was actually quite surprised Hank Brennan called her, to be honest. But we were going to talk about that. And I will still talk about, because the medical stuff I find really interesting. Like, I'd even done some research on hypothermia. I got a scientific paper to show you about hypothermia. I'd got timings of how quick hypothermia comes on under temperatures of that kind, because under normal, ambient temperature, a body only cools at about 1.5 degrees Fahrenheit per hour. So under normal circumstances, you can actually get quite a decent time of death based on the temperature at the time the body was found, and you could track it back. But because it was below freezing, I think it was like 28 degrees Fahrenheit, which I think is a -7, -8, something like that in Celsius. So it was way below freezing, and John O'Keefe was 81 degrees. His body temp was 81 degrees when his temperature was taken. So this would have been when they were attempting to warm him up, because they can't declare someone dead who's been found in freezing temperatures until they're warm and dead. I mean, it sounds horrible, but they've got to warm the body up so that it has a normal body temperature, so they can declare that body dead. Because there has been instances, like rare instances, where people have been frozen and they've actually been revived, like way after the time they should have died. So it occasionally happens, and in that kind of temperature, it would only take about an hour for the body, like after death, to cool to a temperature of 81 degrees. So I got it all laid out. I had the whole thing planned. And I think what I'll do is I'll save that discussion until the defense calls their expert, because I did find Robert Alessi's cross-examination kind of awkward. I mean, he pulled it back. I thought that his recross was good, but I thought, you're going to lose the jury here. Like, there's this really I almost felt like he was nitpicking out. I wasn't sure that the jury would be following it. So I was kind of concerned about Robert Alessi and the way that he was just spending so long on stomach ulcers and stuff. And I even looked those up as well. But obviously what he's doing is he's laying the foundation for his expert. So during the defense case, we're going to hear a lot more about hypothermia. So I'll save that discussion for then. But this is the decisive moment. This is the thing that this trial is going to be known for, in my opinion. So without further ado, I'm going to play it all and I'm going to comment throughout. So this is like half an hour. And it's just, I've no words. I know. Like, Bev was just, she was just like really like matter of fact. Like, where's her grave concern? Like, she had grave concerns. She was almost on the verge of, trying to get Alan Jackson off the case. Grave concerns about the quote-unquote discovery violations that the defence has done with ARCA experts, there's two of them. So where is her grave concern? Because this is way more concerning than anything the defence has done. The defence had no choice but to wait on Arca's new report. So Hank Brennan knew the Arca findings. Arca did the report for the federal investigation. That was what was presented at trial number 1. But it was because Hank Brennan has got these new experts, like he's not using Trooper Paul, who was terrible. He's got his own experts from a company called Aperture. So when they put their report, Aperture report, in discovery, then the defense had to go back to Arca for a revision. Like they wanted Arca's view about Aperture and the Aperture findings. So the defense had to wait because it took so long for the Aperture people to get their act together and actually give them something that they could work with. Then Judge Bev gave them till the 7th of May to release this new report to the Commonwealth. And, oh, the day after the Commonwealth would have gotten that report, like the 7th of May, the very day after, the Commonwealth's Aperture people released a revision to their report. Come on. Anyway, if you didn't watch this, then prepare to be mind blown over this. Okay.
The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are 2 individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until May, not established, they have stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they had associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming.
Right, so this time, 12/31/33, did they say? To 12/31/40 some, right? That's the time that Aperture, and the Aperture report said that Karen Reid's vehicle did this mad reverse and hit John O'Keefe. And the entire defense is predicated upon, and he says this later on, upon the fact that John O'Keefe's phone was active until 12:32 and 16 seconds. Even to the point of John having to use like his biometric identification to open his phone because he read a text message. And then the phone registered 84 feet, just under 84 feet and 36 steps. So, and this was between 12:31:56 and 12:32:16. So 20 seconds. So a 20-second walk, 36 steps, 84 feet. So I did look up, and yeah, it was AI that told me this. That a man at normal walking pace walking 36 steps would walk about 90 feet. So that sounds about right. 36 steps and 84 feet sounds about right. Where does 84 feet take you? Okay, I'll show you. I'll show you where 84 feet takes you. Hold on, I'll have to crack open Google Earth here. Don't know why Google Earth takes so long to open. Right, just let me get this situated, because I've got to come out of this share. It's annoying that I have to do it like this. Okay, right. Here we have 34 Fairview Road. You'll all be familiar with 34 Fairview Road. And John's body was found in the area of the flagpole 8 to 10 feet away from the curb. So that's where my pin is, just approximately. Right. So let's imagine Karen, right? Karen comes along this way, right? Ryan Nagel sees her parked right here, right? And where does 84 feet take you? Shall we measure it? Okay, let's. All right. So let's say John O'Keefe gets out of the car here. And let's just say, for argument's sake, there's, let's say, I don't know, Brian Higgins waiting for John. Let's say Brian Higgins is waiting for John behind this gate here. This is a gate into the backyard. And I've had it in my head for ages now that maybe John didn't go into the house. Now, I know Karen Reid has said that she saw John going into the house. And Karen opens her big mouth and shouldn't be talking. Because I'm not sure that Karen saw him going into the house. I mean, she says she saw him going into the house. I wasn't there. She was. But I've had it in my head for ages that what if John O'Keefe didn't go into the house, and whatever happened behind this gate here, because Brian Albert in trial 1 said that he let Chloe out into the backyard when he got home to do her business. Brian Higgins is all fired up. Brian Albert isn't going to stop him. What if Brian Higgins is here and he shouts and he says, "Hey, John, come up here, over here, over here, over here." All right, let's measure it. Let's say he gets out of the car here. Where's my little thing gone? There it is. 84 feet we're looking for. All right, right. Hold on. It's being arsey. Okay. 84 feet. Oh, look. That's 83 feet. Is that by chance? Is that complete by chance? That just behind this gate, you end up at 84 feet? I don't know. Maybe it's a coincidence. Maybe it's a coincidence. But that's been in my head for ages. Okay. All right. Back to this.
That information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to give it. So, although it was dated May 8th, we received it actually on May 11th. And in that
So May 11th, they received it, May 11th. So written on May the 8th, 1 day, just 1 day after Arca would have given the Commonwealth their report. Just 1 day later, Aperture releases an update to their report. But the defence only got it on May the 11th. So he's talking here May 15th, and they've been stuck in trial like the whole week. So every like night they'll be preparing for the next day. So not a great deal of time to really study new things coming in. And they've had 4 days to think about it. So here's Robert Alessi saying this isn't on.
report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And
Of course it is. Of course it is. So their amendment has taken it from John being hit at 12:31 and 30 some seconds to the exact moment, to the second, that John O'Keefe's phone stops moving, having walked 84 feet. Because they know they have to change it. They know they have to change it. Because John O'Keefe can't be reading text messages using biometrics to open his phone after the time that Karen Reid supposedly hit him, because he has a massive set of skull fractures. So he's not reading text messages. Once that skull's broken, he's not reading text messages. I can promise you. He's lying, dying. So, of course, to the second, they've not even tried to disguise it. They've not even tried to disguise it. Unbelievable.
Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say,
yes, and it was Whiffen's analysis of John O'Keefe's phone that gave us all of these numbers.
That information is literally by seconds determinative in some ways of various analysis. So we basically,
and normally in a case, like a handful of seconds, like 20 seconds, 30 seconds, 40 seconds, doesn't matter. An analysis to the second normally isn't needed. But in this case, every second matters, because in those last moments that John O'Keefe's phone was active until obviously 6 o'clock in the morning, it was busy. John was clearly interacting with that phone, and that phone was clearly moving until 12:32 and 16 seconds. So the entire defense is based on this second by second analysis that the Commonwealth's own expert has testified to, and he's testified to this already.
commissioned, if you will, ARCA to be looking at matters based upon the Infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information.
So 38 to 43, so 5 seconds. So 12:31 and 38 seconds to 12:31 and 43 seconds. So there's that 5 seconds. So this comes from an analysis of the infotainment system. So this is the 5 seconds where Karen is supposedly like driving in reverse at 24 or whatever it is miles an hour to hit John O'Keefe in the right arm. His right arm doesn't get broken. No. Gets a few scratches, but not broken, no. But he pirouettes through the air, not before leaving a hair. He leaves one hair on the side of the vehicle. This absolute magic, miraculous hair. Doesn't leave any blood or anything, but leaves miraculously one hair. And pirouettes through the air. In the testimony, what was it, 2 days ago, Hank Brennan claims that the grass stains on John O'Keefe's arse, like on the butt of his jeans, comes from his impact with the grass. So Hank Brennan is believing that John O'Keefe hits the ground on his arse. Well, that's broken his fall. So how does he have a catastrophic head injury? Yes, of course, if you pirouette through the air and then land on your head, you are likely on frozen ground to get a catastrophic injury. But not if you've broken your fall. We talked about this the other day. If you've broken your fall, all the force has gone out of the impact. But there's no damage to John O'Keefe, not even a bruise on his arse. No broken spine, nothing, no damage whatsoever. So that's nonsense. I mean, unbelievable. This case needs to be dismissed. They can't say how John O'Keefe died. They can't say the manner in which John O'Keefe died. There is no evidence. There was no clear evidence that Karen Reid has done anything. This case needs to be dismissed. This is just gone beyond a joke now. Gone beyond a joke.
That has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA. It's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate.
It is. It's there. It comes down to this. She can't have hit John O'Keefe if John O'Keefe was interacting with his phone after the time that she supposedly hit him. So that's the basis of their entire defense. Everything else can be debated, but if they've got actual, timestamps, it proves it. Surely it proves it beyond a reasonable doubt that she couldn't have hit him. The injuries tell me she couldn't have hit him. It's just completely. He'd have to become some kind of stunt man to pull off a fall like that. No. The injuries do not work. And the prosecution know these injuries do not work. But it is a matter of debate. But when you've got actual timestamps, then that's solid. That is solid.
Evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what
Of course it's calculated. Of course it is. Or is that just yet another coincidence? It's a coincidence that John O'Keefe's phone walks 84 feet and, oh, look, the curb to the back gate is 83 feet. That's a coincidence. It's a great coincidence. But this, the fact that the Arca report would have come in to the Commonwealth on May the 7th, and then, oh, lo and behold, they released this new report from Aperture on May the 8th. Unbelievable. No. No. Oh. I do believe in coincidences. I know some people say there's no such thing as coincidences. There is. There is. Coincidences happen. But this, no. Sorry, no.
I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis.
When I heard that live, right, I was literally crying. I was laughing so hard with just incredulity that I had tears. I had tears in my eyes because I was just laughing so hard. It's just unbelievable that this is not because he's done a new calculation and like added some seconds on because maybe there's, you know, one else thing to consider, or maybe there's a time delay or something. But no, it's to align with John O'Keefe's phone. So this is not even a reanalysis. This is just, oh, well, I'll change the time then to align with Whiffin's results. So this expert just done this off his own back, because when Brennan stands up, he says, oh, I was surprised to receive this new report. Says he's surprised. You seriously couldn't make it. Look, you couldn't make this up. If this was in a Hollywood movie, I'd be like, come on now. This is silly now. This is getting really silly now. But no, this is real life. This is a man who's lost his life. This is a woman who has been practically bankrupted by this outrageous case against her. And two families, the O'Keefe family and the Reed family, who've been upended by all of this. And two children, already orphans, who must not know what to think about their uncle's death. It's just absolutely tragic. And then you've got the likes of Hank Brennan, who will win at all costs. No, this is not how justice works.
And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it.
Too right. Hank Brennan, little whiny voice that he has, saying that, you know, this is a trial by ambush, tried always to get the ARCA testimony, like, banned. Tried always. Like, said, oh, I don't want to ban ARCA, but tried always. The little slime ball that he is. I mean, look, fine. He's doing his job there. All right. The most damaging experts on behalf of the defense, of course, Hank Brennan isn't going to want them to testify. So, you know, it's lawyering, that's all. I can cope with that. But he's engineered this situation now that he knows ARCA are testifying. They've given the report in on the day that Judge Bev told them to, and they've done it. So now he's panicking. So no one could persuade me that this isn't a calculated move by Hank Brennan. No one. This is true trial by ambush.
And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ARCA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just a quick point that this is really much different than ARCA because
I'll tell you why this is much different. Because ARCA's revised report, right? So the original findings still stand, but their revisions were to counter the Aperture report. And because the Aperture report was late, or not, it came in and then it was just like way too long and they couldn't work with it. So they had to wait for revisions, then they could do their work. That's how all this has come about. And Bev wouldn't continue the trial. She said, no, we're going on this date. This date's decided. So she wouldn't entertain any continuances while, you know, they waited for ARCA. She wouldn't entertain that. So now she's asking him, well, is there any other remedy to this? Because she's still harping on about her grave concerns, what the defence has supposedly done. But what the defence has done was what's the word? Unavoidable. Unavoidable. If she'd allowed them to have like a month's continuance, then there wouldn't have been an issue. This wouldn't have happened. None of this would have happened. Because ARCA would have given their report in good time. And then Aperture wouldn't have had to, you know, they could have manipulated time sufficiently. And then at least both sides would have those reports and could work with what's in those reports. As it stands now, this is trial by ambush. And this is perfect appeal fodder. But why should Karen Reid get convicted based upon this completely slimy move and spend time in prison awaiting an appeal? Why should she have to do that? Because then she has to go through an entire appeals process, which can take years. So it's all very well saying, oh, yeah, well, she can appeal and this is great appeal for her. Yeah, it is. But why should she have to? The remedy here is dismissal. That's the remedy. Dismiss the case.
Reasons. We are the defense. And ARCA is a rebuttal to the prosecution's case. that is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right.
have
So-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion in a Rule 14 violation.
And you're not waiving that.
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't given what's been going on. I haven't even had a
Right.
chance to talk to ARPA.
All right, so tomorrow morning, let me know that. All right,
I'd love to know what Jackson's whispering there. I'd love to know. I'd love to know. So she's now entertaining the possibility of a continuance, but she wants the answer today. So he's not had a chance to speak to Arca. And is Jackson saying, "Oh no, we don't want it continued. I don't know." So maybe something is gonna happen today. Maybe there's going to be another discussion on this today. Hopefully, it will be case dismissed. But honestly, I very much doubt it. So you know, let's not get ahead of ourselves here.
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen, I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense, in theory, is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor.
all right, thank you.
All right, thank you. You know, light-hearted. Thank you. Is there a reason given why they skipped court for a day? Yes, a health concern, an unavoidable health concern. So even though it hasn't been stated, it's kind of common knowledge that it was Karen who was ill. But that's why. Exactly. Alec Baldwin's judge would have thrown this case out long ago. Yeah. Now, I didn't watch that trial, but I did watch the hearing where the judge dismissed the case. And, it takes a lot for a judge to do that. It takes some guts on behalf of the judge to do that. But it's the right thing to do. When the evidence isn't, when you know that you're not getting a fair trial here and the evidence isn't stacking up, then the judge has the power to dismiss the case.
Brennan.
Your Honor, this disclosure is not a Rule 14 violation.
Look, I'm not a lawyer. I'm certainly not a lawyer in Massachusetts. But all of the discussion that they had regarding Rule 14 discovery violations in relation to ARCA, this is exactly the same scenario that Hank Brennan painted that the defense had done. And Judge Bev ruled, due to all her grave concerns, that, yeah, there was a discovery violation and they had to have this new report in by this date, which they did. Yeah, Koberger's Judge Hippler, he takes no shit either. Right, exactly. Did you watch his hearing yesterday? I watched it. And it was quite boring. All about the trial. And, he runs a very tight ship. Judge Hippler. He's going to have that court running like clockwork. But this is just absolutely outrageous.
Commonwealth, just like the defense is entitled, continues to work on their case and study the case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There's a clock in a Lexus that runs on a different time than that of an iPhone.
Okay, if you knew that from the jump, then why didn't you take that into account? Why didn't Aperture take that into account? So clocks are different. All right, clocks might run different time. Right, a clock might be running fast, a clock might be running slow. But there is actually a time, isn't there? There is actually one time. Time is, you know, like the atomic clock is the time, isn't it? The atomic clock is the world's time. And phones and digital stuff like aligns with the atomic clock, or at least it should. Now, apparently, he goes on to say, and I'm getting ahead of myself, that John O'Keefe's phone, oh, surprise, surprise, was running fast. And I thought, surely that's ridiculous, because John O'Keefe's got an iPhone, and surely iPhones don't run fast. So I did look it up. And there was a version of iOS. It was iOS 9 that you have to go into the bowels of Reddit to find this kind of stuff, right? But in iOS 9, there was an issue with some people's phones gaining a few seconds every day. So if you were keeping a check, your phone would eventually start to run noticeably fast. Apple did rectify the situation and like put out a new update and it corrected it. But for some reason, and there's an explanation as to why that I don't understand really, but I believe it, there was a reason why this particular version of iOS wasn't aligning as quickly as it should have been with the atomic clock, and it was causing the phone to gain a few seconds every day. Now, I know that John O'Keefe had an iPhone 11, but what we don't know is what version of iOS he was using. I suspect he was using a more recent version than iOS 9, though. What version are we on now? iOS 17? I'm not sure. I'm not sure what version of iOS is the most recent, but I'd like to know what version of iOS John O'Keefe was using. And if it was a problem in iOS 9, maybe, possibly, it has been a problem in other iOS versions that I've just not found in the bowels of Reddit. So even though it does sound incredible and unbelievable that an iPhone might be, you know, running the wrong time, it is possible. Now, it was discussed in Ian Whiffin's testimony that clocks on iPhones can become disoriented. But that was the defense's argument, that there's different clocks that might be used by certain apps. That was the defense's argument. But what Brennan is saying is that John O'Keefe's phone was running fast. And that's why Aperture have had to modify their time to align with John O'Keefe's phone, which was running fast. Bullshit. I don't believe it. I just don't believe it. That's an excuse.
If you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at a precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time given the clocks.
All right. This is easy to prove it then. Do a VOD and have Aperture show us how John O'Keefe's phone was running one time and Karen Reed's vehicle was running another time. So which is correct? So what you'd have to do is convert it all, is understand how wrong that time was, convert it to Unix time, and then you can align the two. So has that been done? If so, let's see the results of that outside of the jury. That's the solution. That's the solution. Prove it. Prove it.
At different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as witnessing the potentially call. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means
always ran late. Always ran late. Well, if it was always running late, it would be constantly gaining then, wouldn't it? So John O'Keefe's phone, unless he, like, there's a fix for it, like if you find that your phone's running wrong, then you can go into your settings and you can attempt to fix it. However, let's see exactly how fast John O'Keefe's phone was running. If you're saying John O'Keefe's phone always ran fast, prove it. So how fast was it running? Did it happen to be running 20 seconds fast by any chance? If so, then Hank Brennan, he's got himself now into an absolute bind. Because if he's now saying that John O'Keefe's phone was running fast, so how fast? Let's say 20 seconds fast. So the phone says it stopped moving at 12:32 and 16 seconds, but actually everything happened. It stopped moving 20 seconds earlier, let's just say. But now the aperture expert has said that the collision happened at exactly that time, 12:32 and 16 seconds. So how then would John O'Keefe's phone stop moving 20 seconds earlier? Would John O'Keefe do all these things, get out the car, walk 84 feet, stand there for 20 seconds doing nothing, and then get hit? Because that's now what you've taught yourself into. So without proving that you've got an exact time for how fast John O'Keefe's phone was running, you've actually painted yourself into a real bind now. You've got yourself in a real pickle now. I don't know whether he realizes it, but he has. So what we need is the proof of the exact time, the conversions, the exact time, John O'Keefe's phone and the infotainment system in Karen's car. They just need to work that out, and we're good.
If the text screen data or the black box data from the car has a event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times.
Yeah.
We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data.
Relative to the time that he needed it to say. So he's done some jiggery pokery that is not aligning with reality. He's manipulated time.
Whoever just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then,
okay, so the time estimates are wrong. How wrong? How wrong?
And he looked at the time of the event of the ignition.
So basically, that's saying that all the times that we've heard so far in the trial are wrong. Is that what you're saying?
On and off. And he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was instead of guessing that it was within the 30.
All right. Okay. So the Waze data. So that's the app that John was using to get directions to 34 Fairview, the Waze app. Right. Okay. Good. So we know what clock the Waze app uses. So that clock is that clock, the actual time. If not, then correct it. Right, compare it to units time, convert it, do whatever you need to do. And then the Lexus, okay, so he's compared the two. He's compared the Waze app and John's phone. And why is he using the Waze app? Why is he not just using John's phone? Why is he not just using the clock on John's phone? Why does it have to go via the Waze app? You're creating an extra level of confusion there. Just use the clock on John's phone, the system clock, the basic system clock. Use that and compare that with the time that Karen Reid's time. Jesus Christ. That the time Karen Reid's car's using. But you're not going to do that, are you? You're not going to do that because you need all these extra little steps to make it more complicated than it needs to be. And you can't match it up based on activity. You've got to match it up to actual time. To time. Anything computerized syncs time. It does, however, there are some glitches, as I just said about there was a glitch in iOS 9. So iOS 9 is an old version now, but if it did happen once, it may have happened again. And Apple had to fix it because people's iPhones were starting to run a few seconds fast every day. And obviously it starts to mount up. Let's say you're gaining 5 seconds a day. It's not long before you've gained a minute, right? So it's a known issue, but I don't know whether it would be an issue for John O'Keefe's phone. And why would it be an issue for John O'Keefe's phone and no one else's phone? So we need to know. We need to know the specifics of John O'Keefe's phone. Something tells me we're not going to get that.
Exact window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision.
Oh, so it just happens that the discrepancy between the Waze app and Karen's car was 20 to 21 seconds. Oh, isn't that just convenient? Great. Isn't that convenient?
Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moment when Mr. O'Keefe last had user interaction, and that reconciles with the data.
Oh, does it now? So John O'Keefe's phone was running 20 seconds fast. So now everything else aligns. Okay. So why has Aperture now put it in their report that the collision happened at 12:32 and 16 seconds? Because no, you've added 20 seconds to align with John O'Keefe's phone. But if you're saying John O'Keefe's phone was running 20 seconds fast, why have you now converted Karen's clock time? No. No, just simply no. Put this in front of a jury and it's reasonable doubt all day and all night. Dismiss this case. Good God.
Not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over.
I was surprised to receive it. I was surprised to receive it, but I welcomed it. If he was surprised to receive it, so the expert just did this completely off his own back. All right, you're surprised to receive it. All right, no, you weren't surprised to receive it. You asked for it.
On May 8th. There was no delay. It's been a week now. The defense has had this information. And so...
No. It might have been written on May the 8th, but they only received it on May 11th.
Not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you?
But no, what the witness that introduced John O'Keefe's phone data was a Commonwealth expert. And he's saying that this new Aperture report was in response to the previous testimony to align it with John O'Keefe's phone. Okay. But that's exactly the same as what Orca did. Orca had to revise their report to respond to Aperture. So it's exactly the same situation. So if Judge Bev deemed that to be a Rule 14 violation, why is this not also a Rule 14 violation?
Do you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
My case in chief, because we now have this available data. As I said, this wasn't ambushed, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his four
Thank you.
categories quickly. He said he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within this reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is...
Yes, Whiffin talked about it. Whiffin talked about it. The Commonwealth's witness talked about it. The different clocks. And he explained how the times he was testifying to were correct. That's exactly what Whiffin said.
Almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All
trial.
right. I thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
I knew
Your Honor.
Aperture wasn't. I thought he may have been something. The name just sounded
Neither
familiar.
Burgess nor Welcher were
Okay.
part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This
Yeah, the new report that Hank Brennan was surprised to receive. Come on now.
variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay. So what I'd like to do, because I want to address the other issue and I don't want to keep people here too long. Can you wrap it up, Mr. Alessi, or is that?
Oh, can you wrap it up, Mr. Alessi? Don't want to hear everything you've got to say, Mr. Alessi. Just wrap it up. Yeah, because it's past 4 o'clock. It's past 4 o'clock. She needs to go home. She turns into a pumpkin.
60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it because they're surprised to get it.
Exactly. They're surprised to get it. So why bother using it at all? If you're surprised to get it, oh, what's this that's come through the mail?
And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay. Thank you. The other issue
Oh, thank you.
about,
Doesn't seem to have much grave concern, does she? She's not shaking like she was when the defense called her grave concern. Like you could hear it in her voice. She was fuming. No grave concern here. Just, oh, thank you. If like she just received a delivery or something. Well, thank you.
calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, efforts of the defense were improper. And inevitably, we've now...
Yes, and that was wrong. That was a wrong decision. But seeing as she made that decision, and that's all on record, this is exactly the same. Or this is worse. This is 10 times worse than any discovery violation that the defense might have done. This is true trial by ambush. Truly.
Received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. In the court.
Well, what have you now done to the defense? What have you now done to the defense? It's 10 times worse.
Understandably, has overruled government suggestion and has stated that it's going to allow the defense to proffer 2 expert witnesses in a very complicated field.
You know what? He's trying to get ARCA banned again. That's what he's trying to do.
The heart of this case. If you're going to allow them to testify, despite the fact that we have not had the time to review, and to prepare, and to address it.
Oh, so you've not had time to review the ARCA report, but yet you were surprised to receive a revision based on that from your expert. Something's not adding up here, Hank. Sorry, I don't believe you. So he's now saying he's not had time to review the ARCA report that he would have received on May the 7th, which is over a week ago. So minutes previous, he said, oh, well, the defense has had the revised aperture report for a week, which they haven't, had it for 4 days. But he's had the revised ARCA report since May the 7th. So what's good for the goose is good for the gander. If he doesn't have time to read the ARCA report and, make sure he responds to it in his case, then how come his expert has responded? But in addition to that, how can you say that, oh, well, it's fine because the defense has had a week when you've had over a week to deal with the ARCA report? What you're trying to do, Hank, is get the ARCA experts banned. And you've got the judge on side because she's already said that there's a discovery violation relating to ARCA. So he's trying to put the final boot in to get ARCA banned.
The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure.
Yeah, it has, but you got to do it like fairly. Karen has to have a fair trial to be found guilty beyond a reasonable doubt.
Some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case to the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the...
So that sounds like Hank wants a continuance. His expert has not been able to read through the ARCA report. So Weschler has not had time to read through the ARCA report. Well, Burgess seems to have done, because it's Burgess is the one who's responded, you know, with the surprising new report. But Weschler's not had time. So Hank Brennan seems to be talking himself into wanting a continuance here.
Simple four opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then comparing testimony.
He's terrified of this ARCA report. This tells you how scared he is. He is clutching at straws. That ARCA report must be really damaging. Really damaging. He knows it too.
Address claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of the material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests.
Oh, so the Commonwealth expert, Weschler, Dr. Weschler, has found concerns with the ARCA report, wants to do his own testing. Why? Because ARCA's research, you know, during the federal investigation, this is from the original report, showed categorically that Karen's car did not hit John O'Keefe. So now his experts thinking, shit, probably got on the phone to Hank saying, listen, this ARCA report's pretty convincing, you know. You know, we don't really believe that John O'Keefe was hit by Karen's car. What should we do about it? Well, Hank says, well, fudge the data. Do some more testing and fudge it. I bet you any money that's what Hank said, because he's so dirty.
Demonstrate the failures of these ARCA witnesses. That's going to take time. You've heard from the ARCA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery.
They were given 5 weeks. They were. But they wanted a continuance. They wanted a continuance so that this was all dealt with in a timely manner. And Bev said, no, the trial goes now. And she was the one that gave ARCA 5 weeks and said, oh, you've got plenty of time now to do it. You know, May the 7th, got plenty of time. And Hank Brennan's had to sit on that and worry about it. And now the experts saying, listen, we're going to have to do more testing here. You know, if you want us to fudge this, we're going to have to do way more testing. This is all just my opinion, obviously. I wasn't there, but that's what it seems like.
Deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He's in a difficult schedule. He is away tomorrow, Saturday. We will go to try to begin to prep at the end of the weekend.
Well, Hank sounds like he wants a continuance.
No way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared that he's had adequate time to prepare. If either of these are the witnesses testify and they introduce
What do you mean if? What do you mean if they are going to testify?
new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders. And so that.
Okay, so what he wants, right? What he wants is for his experts to be allowed to come back during rebuttal and respond to Arca's report. But shouldn't that be something that is done under cross-examination? Because you've got your case in chief. Aperture is, as he said previously, Aperture are the experts that he is bringing on in his case in chief to prove that Karen hit John O'Keefe. All right. But then Arca's going to come along during the defense direct testimony and say, no, this is what really happened. So he wants his experts to be able to come back under rebuttal with new evidence, with new testing. He wants to have to respond. He wants to respond with the new testing that his experts have done. But that's not rebuttal, is it? If you're bringing up new evidence, that's not rebuttal. That should be, all that new evidence should be in your case in chief. So he's requesting that he gets a special rebuttal. He essentially gets the permission, the green light from Judge Bev to present all this new information during his rebuttal case. But then what are the defense going to do? The defense is then going to have to bring Arca back. How can this be allowed? How can this be allowed? Listen, Judge Bev has got a really key decision to make here. This will make or break this trial either way. I don't envy her thought process. I don't envy. She probably didn't sleep very well last night because this is as serious as it gets. This is why I think this really should be dismissed. This case should be dismissed. They cannot say how John O'Keefe died, why John O'Keefe died, who's responsible because of the absolutely shocking police investigation. They can't, there's no way this can be resolved, really, there isn't. And if they try to just whitewash over the terrible police investigation, the autopsy results, the lack of relevant injuries on John O'Keefe's body, if you try to whitewash over all of that, what you've got left is this absolute shit show of debating 20 seconds of time. That's all you've got left. That's that the case hinges on. And that is not justice. It's not justice for Karen Reid. It's not justice for John O'Keefe. It's not justice for the O'Keefe family. It is absolutely complete and utter shite. That's all it is. This needs a dismissal. This has gone on long enough. This cannot be resolved, in my opinion. We'll never know how John O'Keefe really died. That's my opinion now, because the evidence wasn't collected. The police didn't do their job. And now you're trying to make a silk purse out of a sow's ear, and it just does not work. And this proves it. For me, this is the final straw. This proves it. Dismiss this case.
He can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess' information material. It will make no sense. I thought about it. It makes no sense to the jury, this presentation, unless Shannon Burgess has an opportunity to provide background information.
Right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think
Hurry up, though. Hurry up.
and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good.
Oh, yeah. We can't focus on the fact that the ARCA report has been known all of this time. That ARCA testified during trial 1, and the ARCA report was due to a federal investigation of the matters here. Let's just not mention any of that. Robert Alessi, what are you thinking? Let's not mention any of that. Let's whitewash over all of that, because that doesn't help the Commonwealth, does it?
Because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that. So
we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, and we talked about what you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial.
Exactly. The defense has done everything that Judge Bev told them to do. So whatever discovery violations she found has now been rectified. So ARCA should be able to testify as any other defense witness. And, oh, well, so what if Hank Brennan can't get his experts together to deal with it? Because that was a decision made by the judge, not the defense, the judge.
With that information, we complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address.
Exactly. Norfolk County Kangaroo Court in full flow. Oh, she left it open. The defense has done everything she asked, but oh no, she left it open, to make put more obstacles in the way, presumably.
This matter is if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost...
If she allows this and Karen Reid gets convicted, this is an appeal all day and all night. But Karen Reid should not have to endure going to prison with the hope that at some point down the line, she gets an appeal granted. And then what happens then? There's a whole new trial that she then has to pay for, having been in prison for probably like 2 years at that point. Unbelievable. If Judge Bev goes with that, then there is literally no justice left in the world. I thought Delphi was bad, but this, if she allows this, that's as bad.
So facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor.
Oops, sorry.
The final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right. So I have a question for you, Mr. Leslie. Are you still thinking that if the defense puts on a defense that will
The world is watching, Bev. The world sees what's going on.
take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this because obviously you have no burden. If ARCA is part of that defense, when in that week and a half?
What do you mean if ARCA is part of that defense? I don't like how she keeps bringing if ARCA is part of that defense. She knows ARCA is going to testify for the defense. Why does she keep saying if? That makes me nervous.
Time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Court, all rise.
Right, all rise. Well, yeah, the world was watching Delphi too, and look how that turned out. That's a very good point. That is a very, very good point. Look, seriously. What am I doing here? I don't even know what I'm doing. All right, there we go. Look. Today, are we going to hear some good news? No. No. I don't think we're going to hear the news that we should be hearing. That this case is an absolute farce. It's gone beyond anything that can be safely and judiciously concluded now, and it needs to be dismissed. But no, we're not going to hear that. We're not going to hear that. We're going to hear some kind of whitewash that allows the Commonwealth basically to do what they want and the defense to have to just suck it up. That's what I predict is going to happen. I hope I'm wrong. I've been wrong before. I hope I'm wrong, and I'm pleasantly surprised that Judge Bev comes up with, something that makes sense. What that might look like, though, I have no idea because I'm not a lawyer. She may surprise us. Yeah, she may surprise us. I mean, she's going to have tossed and turned all night. She's not going to have slept well because this is a monumental decision to make. This makes or breaks this case. It really does. It opens her up to all sorts of criticism, not just from us, random people chatting on the internet, but from her peers. So let's wait and see. And we don't have long to wait because we've got I'm losing track of the days. Are we day 17? I think we're day 17 today. So in 3/4 of an hour, She's always late. So let's say an hour. In an hour's time, maybe we're going to hear some words from Judge Bev. Maybe we'll hear words. Who knows? All right, guys. Thank you for joining me. A little bit longer than normal, but not too bad. Not too bad. So, yeah, thank you. Another lovely day here. So I'm going to go and pull some weeds up out of my garden, I think, this afternoon while I'm listening to the trial in my ears. All right. Thank you, mods, as always. And, yeah, enjoy the rest of your day. Oh, also, there's a Lily and Jack Sullivan video, which is queued up. I'm going to release it within the next 10 minutes over on Michelle After Dark if you're following that case. So, all right, I'm gone. Bye, guys.